Welcome to the deep dive. This is where we take the sources you provide and, well, really dig into them to pull out the key insights for you.
Hmm.
Think of it as your personalized briefing. Today, using the materials you sent over, we're diving into the English legal system. Pretty fascinating stuff.
Absolutely. And whether you're coming in already knowing a bit or you're just starting out, our goal here is to give you a clear picture. We want to look at its foundations, and it's really quite remarkable history.
Yeah, without getting bogged down in too much jargon, hopefully.
Right. We'll be unpacking what law actually means in England and how it's changed over a millennium, really,
Yeah.
all based on those definitions and historical bits you shared.
Exactly. Your selections are great. They give us the definition and that historical sweep. So let's start right at the beginning. What is law in England, fundamentally?
Okay. So, in essence, English law is it's a system of rules. Rules the country expects everyone to follow.
Right.
And crucially, it's not just guidance. There are consequences, mechanisms in place if people don't comply.
Okay, got it. Now, something that jumped out straight away was the focus on the English system specifically, not, say, a British one. Why is that distinction so important?
Ah, yeah, that's key. It really reflects the UK's history. As maybe one of your diagrams showed, Scotland and Northern Ireland actually have their own separate legal systems.
Oh, right.
It's a result of how the UK was formed, the Acts of Union and so on. They kept their distinct legal traditions.
Okay, that makes sense. So we're zeroing in on England. Now, where do these laws actually come from? The sources mention two main types, statute law and case law.
That's right. Those are the two pillars. Statute law is the law made by Parliament.
Ah.
These are the acts of Parliament. And they're like the highest form of law in England.
And you can find those. Where?
You can find the actual text on the official UK government website, legislation.gov.uk.
Okay, so that's the formal written down law from Parliament. What about the other one, case law? How does that work?
Right, so case law is sometimes called common law or the precedent system.
Yeah.
This is law that develops from decisions made by judges in actual court cases.
Mm-hmm.
The reasoning behind their judgments sets principles. And judges in later, similar cases are generally expected to follow those principles. It's all recorded in law reports, accessible through legal databases.
So wait, a decision by one judge can bind another judge later on?
Yes, particularly decisions from higher courts. They set what's called a binding precedent for the lower courts. It ensures consistency.
I see. So it's like building law case by case based on past wisdom. Okay, now the sources also split law into different categories, criminal and civil law. That seems like a major divide. What's the core difference there?
It is a fundamental split. Criminal law deals with behavior that's seen as harmful to society as a whole, like theft, assault, that sort of thing.
Okay.
When a crime occurs, it's the state, usually through the Crown Prosecution Service, that brings the case against the accused person.
Right. The state prosecutes.
Exactly. And if the person is found guilty, the outcome can be punishment, like a fine or even prison. It's interesting, though, while most crimes today are defined by acts of Parliament, some really serious ones, like murder, are still defined by that old common law tradition.
Wow. Okay, so that's criminal law state versus individual, with punishment as a possible outcome. How's civil law different then?
Civil law is about the rights and duties between individuals or between companies or individuals and companies. It's about sorting out disputes between private parties.
So things like,
Like if someone crashes into your car because they were careless, that's a civil matter, negligence. Or if a company doesn't fulfill its side of a contract.
right, breach of contract.
Exactly. In these cases, the person who feels wronged brings the action, not the state. And the goal isn't usually punishment in the criminal sense. It's more about putting things right. Maybe getting compensation for damages or forcing someone to do what they promised. The state provides the court system, the rules, but it's not a party in the fight.
Okay, so state as prosecutor versus state as, like, the referee providing the ring. Got it. The sources also mentioned public and private law. How do those fit in?
That distinction overlaps a bit, but it's about who is involved. Public law generally involves the state or government bodies. So criminal law is a type of public law. Constitutional law, how the state itself works, and administrative law challenging government decisions. Those are also public law.
Right, state involvement.
Yeah. Private law, on the other hand, is purely between private individuals or entities. The government isn't directly involved. Think contract disputes again, property disagreements, personal injury claims, those are typically private law matters.
Okay, clear. Presence or absence of the state. One more distinction. Substantive and procedural law. What's the deal with them?
Yeah, this is important for how the system actually operates. Substantive law is what it defines our rights, our duties, what's legal and what's illegal.
Like the definition of theft you mentioned earlier.
Exactly. The rule that says unlawfully taking someone's property intending to keep it is substantive law. Procedural law is the how. It's the rules for how substantive law is applied and enforced.
So like the court process.
Precisely. Rules about how police can gather evidence, what evidence is allowed in court, the steps you have to follow to sue someone, how a trial is run, that's all procedural law. It dictates how the legal system actually does things in response to the substantive rules.
That makes perfect sense. Substantive is the rule. Procedural is how you use it. Okay, great. We've got a good handle on what English law is. Now let's switch gears to how it got this way, the history. The sources kick off way back in 1066 with William the Conqueror. What was his big impact?
Well, 1066 and the Norman Conquest, that was obviously a massive turning point. William established Norman rule, and for quite a long time, power was really centralized in the king.
Absolute power. Almost.
Yeah, pretty much, initially. But even under that strong royal control, the very, very early seeds of the English legal system were sown. You start seeing basic ideas about land ownership, ways to settle disputes, early notions of criminal justice starting to form, even if it was all ultimately up to the king.
So very top down to begin with. But then fast forward a bit to 1215 King John and Magna Carta. This seems like a huge deal in the materials. Why?
Oh, Magna Carta is fundamental. King John was, well, not very popular with his barons. They basically rebelled and forced him to agree to certain limits on his power.
Forced him.
Yeah. And this document, Magna Carta, laid down some incredibly important principles. Things like the right to a fair trial, protection from arbitrary imprisonment, and critically, the idea that the law applied to everyone, even the king.
Wow. Okay, that is big. In an age where kings were often seen as, almost divine.
Exactly. The idea that the king himself had to follow the rules, that was genuinely revolutionary back then. It's a cornerstone of the rule of law.
So that really set a precedent, didn't it? What happened next in terms of courts and things?
Well, the system developed gradually. At first, the king might hear disputes personally, maybe with his council. But as things got busier and more complex, he started delegating to officials, to judges. And that's how a more formal court structure slowly started to emerge over the centuries.
And around the same sort of period, Parliament starts to appear. The name comes from talking, right?
That's the origin, yeah, French parlor, to talk. Initially, it was really just a meeting for the king to get advice from important people, nobles, church leaders, wealthy landowners.
An advisory council, basically.
Pretty much. But over time, it evolved. It split into the two houses, wards and commons. And crucially, certainly by the 14th, 15th centuries, the idea of electing members to the House of Commons started taking root, although monarchs weren't always keen on that.
I can imagine.
But we see evidence quite early on, like an act of parliament getting royal assent from Henry VIII back in 1497. That's the final approval from the monarch, a tradition that still happens today.
Fascinating. Okay, moving on chronologically, we hit Henry VIII, famous for other things. But how did his break with the Catholic Church affect the legal system?
Yes. The annulment saga. When the Pope refused to grant Henry his annulment, Henry took the radical step of breaking away from the Roman Catholic Church entirely.
Creating the Church of England.
Exactly, with himself the monarch as its head. Legally, this was huge because it removed the influence of Roman Catholic canon law from the English system.
So it made English law more English.
In a way, yes. It separated it from that continental influence. And while the king was still massively powerful, it did sort of lay some groundwork for more independence for the English courts down the line, though that took time.
Right. So personal drama having massive legal consequences. Okay, fast forward again to the 17th century. Things seem to get heated between the king and parliament. What was this parliamentary sovereignty idea about?
By the mid to late 1600s, parliament, especially the elected House of Commons, had grown much more assertive. They were pushing the idea that they were the supreme law-making body in the land, not the king.
That Parliament's laws were top dog?
Essentially, yes. That's parliamentary sovereignty. Now, King James II really resisted this. Plus, he was Catholic, and when his son was born also Catholic in a largely Protestant country, it caused a lot of anxiety. Fears of a return to Catholicism and absolute monarchy.
Okay, so a clash of power and religion. And this leads to the Glorious Revolution of 1688. Sounds dramatic.
It sounds dramatic, but it was actually relatively bloodless, which is partly why it got the name Glorious. Things came to a head. Parliament basically decided they didn't want James II anymore.
So they just fired the king?
Sort of. They invited his Protestant daughter, Mary, and her husband, William of Orange, to take the throne. But, and this is the crucial bit, they made them agree first that Parliament was the supreme lawmaker.
Ah, condition.
A very important condition. William and Mary accepted. James II fled, effectively abdicating. And legally, it's fascinating because Parliament deliberately bypassed the direct heir, James's Catholic son, showing that Parliament now held the ultimate power, even over succession.
That's a massive statement about where the power now lies, and this was all cemented in a law.
Yes, the Bill of Rights of 1689, a landmark piece of legislation. It formally limited the monarch's powers, strengthened Parliament's role, protected certain rights like free elections and freedom of speech within Parliament, and really embedded that principle of the rule of law.
Okay, Bill of Rights, 1689, key document. Now, around this time, the sources mentioned the separation of powers. This sounds important, kind of foundational for democracy.
It really is. The idea is that government power should be divided between different branches to stop any one person or group getting too much control.
Like legislative, executive, judicial.
Exactly. The legislature makes the laws. That's Parliament in the UK context. The executive implements the laws. That's the government, the Prime Minister and Cabinet. And the judiciary interprets the laws. That's the judges and courts.
And where did this idea come from?
It really gained steam during the Enlightenment, with thinkers like John Locke here in England, and especially the French philosopher Montesquieu. They argued this separation was vital to prevent tyranny. Learning from history. It's now a core principle in many democratic constitutions, including, implicitly, the UK's unwritten one.
Right, spreading power out to protect freedom. Makes sense. Okay, nearly there on the history. The last big thing mentioned is the Industrial Revolution in the 19th century. How did that massive social change impact the law?
Well, the Industrial Revolution changed everything: society, the economy. Huge factories sprang up, cities grew rapidly. This created new social classes. A powerful industrial and business class emerged, wanting more political say.
And the workers?
And large working classes, often facing pretty tough conditions, who started demanding rights and representation too. Society was transforming, and the legal and political system had to adapt, albeit slowly.
How did it adapt?
One major way was through electoral reform. Those Representation of the People Acts, 1832, 1867, 1884, gradually gave the vote to more and more men. It reflected those changing power dynamics and the growing pressure for a more representative system. Law had to respond to these huge societal shifts.
What an incredible journey. From William the Conqueror's absolute rule through Magna Carta, the rise of Parliament, clashes with the monarchy, the Bill of Rights establishing supremacy, the separation of powers idea, and then societal upheaval forcing legal changes.
It really is quite a story. We've seen how English law gets its rules from both Parliament statutes and judge-made case law. We've untangled criminal, civil, public, private, substantive, procedural law. And we've traced that long, winding path from royal decree to a system built, at least in principle, on the rule of law, parliamentary sovereignty, and that separation of powers.
And it explains so much, even seemingly odd traditions, like you mentioned the barristers' wigs and gowns earlier. It all stems from this long history.
Exactly. Those traditions are echoes of this centuries-long evolution.
So for you, the listener, hopefully this deep dive gives you that foundational understanding, that context for how the English legal system works today. And maybe, thinking about this 1,000-year story, here's something to mull over. With the world changing faster than ever, technology, global challenges, what do you think the next major shift or challenge for the English legal system might be?
That's a great question to ponder. It certainly won't stand still. We really hope you found this useful and, keep exploring. If you uncover more sources you'd like us to dive into, definitely let us know.
Thanks for joining us on the deep dive. We'll catch you on the next one.